Major breaking news. The United States Court of Appeals for the 8th Circuit out of Minnesota has found that 18, 19, and 20-year-old Americans have the right to keep and bear arms, and they cannot be denied the ability to carry guns in public for self-defense. They knocked out a Minnesota law that said that you could not get a concealed carry permit until you were 21 years of age. The case of Worth versus Jacobson. Huge win for the Second Amendment. Now, we're going to do a much longer video on this later, but the big thing is, I think the takeaway from this is that 18, 19, and 20-year-olds are part of the people, as in the textual right of the people to keep and bear arms shall not be infringed. The other critical takeaway from this case is that the Rahimi case, which ruled against Mr. Rahimi, but I told you, don't stress out about that decision. That Rahimi case was used repeatedly by the 8th Circuit Court of Appeals here to knock out the gun control law. For example, they cite the Rahimi's language that says, hey, that even if 18, 19, and 20-year-olds were not allowed to have guns at the time of the founding, for the sake of argument, they are now part of the full-blown national political community today. So therefore, they have rights today. So even if you have evidence that 18, 19, and 20-year-olds don't have rights at the time of the founding, they would today, because just like maybe at the time of the founding, you could have banned handguns because they were not really around at the time of the founding in a great way, unlike long guns, but you can't ban them today because the handguns are now ubiquitous. Same idea. It's a one-way ratchet toward freedom. And likewise, they said that the 18, 19, and 20-year-olds have a lot more rights today and freedoms today than they did at the time of the founding, and therefore, the Second Amendment right expands to cover that in the same way that handguns are now protected arms at today, even though maybe they arguably could have been restricted at the time of the founding because they were not, they arguably could have been dangerous and unusual. But neither, the point being that, again, this court is using the Rahimi decision to advance the ball of the Second Amendment rights. They go on also to say that the Rahimi decision points out that you can't disarm people just because they're irresponsible. And arguably Minnesota was making the argument that 18, 19, and 20-year-olds, statistically speaking, are less responsible than older adults. And the 8th Circuit says responsibility, according to the Rahimi decision by the Supreme Court, is not the touchstone. You have to have an individualized determination in a court of law that someone is a violent danger to third parties, and then they can be temporarily disarmed, but that is not a sufficient historical analog, law, or rule that could somehow justify saying no 18, 19, or 20-year-old in Minnesota can carry guns for self-defense in public. Then they go on to talk, and this is very important, about in loco parentis. Remember how I told you at the time of the founding there were certain universities, including public universities like the University of Virginia, that had restricted gun possession by their students. But I told you that those historical analogs were not going to be a problem in modern day America in terms of preventing adults from carrying guns on campuses. And the reason why is at the time of the founding, you had an in loco parentis, i.e. parental relationship between the faculty of those schools on the one hand and the students on the other hand, because the students at the time of the founding that went to colleges were like 14, 15, 16 years of age. They were really children. And today, you do not have an in loco parentis, meaning a parental relationship between schools on the one hand and like university students on the other hand. And you certainly don't have an in loco parentis relationship between schools on the one hand today and the parents, staff members, and adults in the community. And again, this court, the 8th Circuit, did a very powerful job saying, hey, those school restrictions at the time of the founding are not analogous to anything going on today, because at the time there was an in loco parentis relationship that even Minnesota admits to, and therefore that is not a basis to say 18, 19, and 20-year-olds can't carry guns in public today, because the state of Minnesota does not have an in loco parentis relationship between the state on the one hand and 18, 19, and 20-year-old full-blown adults on the other hand. So it's simply not analogous, and he knocked out those alleged gun-free zone schools at the time of the founding as simply not being analogous. I'm going to do a much longer video on this, but I've got a lot going on today. Obviously, a lot of Fox News, Trump stuff, everything going on, craziness. But anyway, with that said, we're going to do a much longer video on the breakdown of this decision. But this is a huge win. Congratulations to the Second Amendment Foundation, to the Firearms Policy Coalition, to the Minnesota Gun Owners Caucus, and to the other plaintiffs. And I think the NRA had some involvement as well. Congratulations to them. And again, make sure you follow me on X at 4boxesdown, and don't forget to subscribe here. And we'll see you again soon here at the 4 Boxes Down.
Orders up. Table 2A.